When I'm questioning a doctor during his pretrial deposition, if the defense lawyer yells out, "Objection! I object to the form of your question," does it mean that his client can go ahead and answer the question? Does it mean I have to change the question around? Does it mean I can't ask that question? You want to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, first of all, you should know that a deposition is a question and answer session that typically takes place in an attorney's office, in pre-COVID times anyway. During COVID times, now this typically takes place over a Zoom call. I am there if I am questioning the doctor, let's say in a medical malpractice case. The doctor is on the call, the doctor's attorney is on the call, and any other lawyers who are involved in the case, as well as a court stenographer, we call them court reporters, who is there to record all of my questions and all of the doctor's answers. The doctor's answers actually represent his sworn testimony and carries the same exact weight as if he's testifying at the time of trial, in front of a judge, in front of a jury, while in court. So even though this may appear to be an informal setting, his answers actually matter a great deal. All right. So during the course of my questioning of the doctor, I ask a series of questions. And now all of a sudden the defense lawyer chimes in and says, "Objection! I object to the form of your question." Now what does that mean? It means the lawyer doesn't like the way I ask the question. There's something wrong with the manner in which I ask the question. Now there could be many reasons about why the form of the question is not proper. Now I may think it's proper, but the defense attorney now, because he raises an objection, has a problem with it. Okay, so what does that mean practically? Two things. One, it means that now he's preserving his right to object, and now it's on the record that he doesn't believe that this question is appropriate. Two, he's alerting to the doctor to the fact that there's a problem, he believes there's a problem with the question, and for the moment he does not want the doctor answering that question. He now has to wait until the attorneys have a brief argument, legal argument, about whether this question is appropriate or not. I have found over the course of my career that many attorneys, when they get an objection to the form of their question, they start bickering with each other. They start arguing. What's wrong with my question? What's wrong with the form of my question? There's nothing wrong with it. And now each side goes back and forth. There's plenty wrong with it. Well, why don't you tell me what's wrong? I don't have to tell you what's wrong with it, counselor. You should know better. You're an experienced attorney. And now this nonsense goes back and forth. So in my experience, in my opinion, the better practice is, instead of getting into that nonsensical argument, well, there's nothing wrong with my question, the doctor has to answer it. No, if you rephrase the question, he'll answer it. There's nothing wrong with it, I'm sticking with my question. Now the defense attorney says, if you continue wanting the doctor to answer that question in the way that you asked it, I'm advising him not to answer the question. So now what do? Well, a good attorney is going to do exactly what I do, which is turn the question around, rephrase it. Okay, I'll rephrase the question. Objection to form. Many attorneys continue to bicker about the form of the question. Rather than getting into a whole argument about the form of the question, you know what I do? I'll rephrase my question. And now I get another objection. No problem, I'll rephrase it again. And I'll rephrase it again. I'll ask it 10 different ways. I'll ask it 15 different ways. I don't care. You know why? Because I am persistent. And I will ask the question that I need to ask, and I'll do it many, many different ways. Now here's something interesting. Even though the defense lawyer has a legal right to make that objection and to put that objection on the record, objection to form, he cannot tell his doctor not to answer the question. Put another way, to rephrase that statement, the doctor has to answer my question according to the rules in New York. Okay? So that even if the form is not proper according to the defense lawyer, the doctor is still required to answer my question. Yet there are still some defense attorneys who can get aggressive and say, I'm not going to allow the doctor to answer that question in the form in which you asked, counselor. Okay, so now I'll ask it 5 different ways. I'll ask it 10 different ways. And I will continue to ask my question until I get an answer. And you know what? If the defense lawyer continues to persist and tells the doctor or advises the doctor not to answer the question, okay, you know what I'll do? I'll make a mental note of that. And now half an hour later, I will come full circle right back to that question and that topic, and I will continue asking questions. Why? Because in my opinion, this particular series of questions are critical for me and my case. And just because the defense lawyer doesn't like my questions, just because he's afraid to have the doctor answer the questions, maybe, just maybe, my form, the way I phrased the question, was problematic. And I'll give you an example. Let's say I asked the doctor, "Doctor, on January 1st when you came outside, it was sunny and it freezing, wasn't it?" If the doctor says yes, is the yes that it was sunny or is the yes that it was freezing? Which one is it? That's called a compound question. What I'm doing basically is asking for multiple answers and the doctor gives me one answer. And that's not a problem with the doctor's answer, it's a problem with the way I ask the question. So instead, the better practice is I ask one question for one fact. Doctor, isn't it true on January 1st it was cold outside? Yes, it was. And isn't it true that on January 1st it was freezing? Yes, it was. Isn't it true, doctor, that on January 1st it was sunny? Yes, it was. Okay, those are simple, straightforward questions that call for yes or no answers. So in that scenario, by asking simple, straightforward questions, calling for only one fact at a time, I'm never going to run into a problem where I get an objection saying, "Objection, counselor, that's a compound question. I object to the form of your question." Okay, but let's go back to the reasons why the defense attorney might be objecting to the form of my question. Maybe he's right. Maybe I asked an inartful question that makes no sense to him or to the doctor. In that instance, it's my responsibility to try and ask the question a proper way. And you know what? In some cases, because I've been asking the doctor questions for hours and hours, I may get a little tongue-tied, or I may not ask the question the way I believe I should ask it. So I'll apologize. I say, "I'm sorry, I didn't ask the question properly. Let me try it again." And now I'll simply continue on asking the question until I get an answer. So why do I share this with you? I share this with you just to open your eyes and to let you understand, hopefully show you exactly what goes on during these medical malpractice cases, these accident cases, these wrongful death cases, and during the course of the lawsuit, what actually happens. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.